that she received her diplomatic passport, and only whenever she was asked for them did she provide that information. That's a key piece that you would sort of develop as you're going through. If you read the testimony, you'll see that it was when the police officer asked about the license plate, that's when the defendant gave over her diplomatic passport, right? So that's a key piece as to whether they intentionally tried to deceive the officer. You could argue that point. So those might be some things that you would talk about. Okay, great. So whenever you're finished, what are you going to do? Yeah, you're going to thank the jury, you're going to head back to your seat, and then we are ready. And what do I do with my clicker? Okay. Now we are ready for some direct examination, right? So we're going to talk about direct examination, cross-examination, and kind of go through each of those. So then we'll do some redirect, recross, and closing statements. So I just want to get you up a little bit on the opening statements. But on the opening statement, like I said, each side have 5 minutes. Prosecution always goes first. They're going to talk about the burden of proof. Defense is going to follow. You want to integrate your theme into that. You want to make sure your theme's coming across. That this person maliciously and intentionally attempted to deceive the officer, whereas this person really believed and is this ambassador that they are purporting to be. You should not use any notes, okay? There should be nothing in your hand whenever you're presenting your opening and closing statement. It's pretty easy to do that because it's 5 minutes and you've got all the time in the world to practice it, right? So you should know it. I mean, you should know what it is. Okay, so now when we get to direct and redirect examination, you have a total of 25 minutes in the course of the round for your direct examination. That's basically about 5 to 6 minutes apiece for each of your 3 witnesses. So you're trying to come up with about 5 to 6 minutes of questions per witness. Sometimes, if you have your defendant, you may have more than you might for another witness. Sometimes if you have your arresting officer, you might have more questions than you would for your other witness. But you want to make sure in total that you're under that 25 minutes, or else you're going to go over time and get cut off. So you don't want that to happen. These are open-ended questions. These are who, what, when, where, and why kind of questions, in which the witness up here is the star of the show. They're the one talking the most. They're the one telling their story, and they're the one really communicating with the jury. So, a couple of things I want you to practice when we get our witnesses up here in a second. And I'm going to ask you, between the witnesses, decide who you are, whether you are the minister or the defendant. You guys would be, one of you would be the officer, and one will be the Secretary of State. One of you will be the defendant, and one of you will be the foreign minister. So y'all decide real quick who's going to do what.
Hey, you already decided.
Okay, we got our decision made?
Yes, sir.
Okay, are we ready? Both sides?
Just do it. Please do.
Defense, do we know who our witnesses are going to be? We got it? Okay, great. So, whenever a witness comes up, they're going to come up here. Typically in a trial, what we try to do for efficiency is before the trial ever begins, our judge would have already had all the witnesses stand and swear in. So we're going to assume that that already happened, but all they really need to do is hold up their hand, and they're going to affirm that they're going to portray their witnesses honestly and accurately. Okay, and so that's what they're going to swear into. Whenever they actually get called, they'll sit in the chair that's closest to the jury box. And I tell you that because it can be a little confusing which chair the witness is supposed to go to. So always look at your courtroom and how it's laid out. It's always going to be the chair closest to the jury box. That's the one that they need to go to. Open-ended questions. So whenever you, as the attorney, are asking your questions, you're doing your direct examination. I want to give you a pro tip. And then I want to give you what you probably should do for now, but I want you to work towards a pro tip, okay? You get more points as an attorney, the less you rely on notes. Okay, that there's a direct correlation between your reliance on notes and your score. So, in order to get to pro tip level, okay, pro level, you would actually probably want to stand here and ask your questions. Why? Yeah, nothing in front of me. I'm completely off script. I can't see anything. I don't have any papers in front of me. It's just me and the witness. Okay? That's what you will see from a very advanced team. A team that has been or really plans on going to nationals. That's what they're going to do. Don't be intimidated by that. Okay? You can get a 10, 10 points out of 10 points for your direct examination without doing that. But like I said, it's based on your reliance on notes. So even if you have notes in front of you, if you're not using them, I'm going to give you the appropriate score, right? Because you're not overly relying on it. Now, if you're reading directly off your notes for every single question, the score's going down. Just keep that in mind. You want to know what your questions are. So, that said, this is direct examination. These questions are designed to let the witness tell their story. So the answer to the question should not be yes or no. The answer to the question should be very open-ended. So for example, what occurred on the day of June 22nd, 2016? Okay, it's very open-ended. They get to answer in a more narrative format. What happened? Who was there? What happened next? When did that occur? Okay, the who, what, when, where kind of questions is what you're trying to ask in your direct examination. The goal, again, is minimal use of notes. So, on our direct examination, let's get one of our prosecuting attorneys to call a witness. So, we have done opening statements. Both sides have said that they are ready to proceed. So, Your Honor, why don't you ask the prosecution if they're ready to call the first witness?
Prosecution, are you ready to call the first witness?
Yes, I am. All right, John and Dean.
Okay, yeah, so whenever, and great job, you did great. So whenever, and you can go ahead and head up. If you want, you can stay here. You don't have to stand up in front. Okay, you typically are going to stay at your seat unless you want to do pro level thing or you want to.
I'll try.
You're going to try it? Okay.
Do it.
Okay. Now, if you're going to do that, before the trial starts, you want to ask permission of your judge. There's usually a perfunctory period at the beginning where you ask for permission to do certain things. For example, to walk about the well. This is called the well. To stand in front of counsel table to ask your questions, etc. So you'll want to, if you're going to do that through the trial, you want to ask permission at the very beginning of the trial. Okay? I just want to make you aware of that. Okay? So whenever we are doing our questioning of our witness, this is our police officer. Officer, what's the name?
John D.
John what?
John D.
John D. Okay. So this is our police officer. We're going to ask him some direct examination questions. So what kind of questions would you start off with when you're talking to this officer?
Oh,
Establish his character.
I am the prosecutor.
Establish what?
His character?
Okay. Well, let's start off with even more fundamental than that, although you're getting to the right point.
Who is he?
What is your profession?
Well, more importantly,
What is your name?
yeah, right? Okay, so what are you going to ask him?
Witness one, what is your name?
Yeah. Well, yeah, is there, officer, so please introduce yourself, or please please state your name for the, or say something along those lines.
State your name for the jury.
My name is Jan Dean.
Okay, and so then you would ask him what?
What is your profession?
I am a police officer for the state of Texas.
You're doing great. Okay, what else would you want to ask him?
And what were you doing on June 22nd?
I was to patrol the Yarbo Turnpike.
And what happened to make you come along our defense? To make you come across our defense?
I spotted a vehicle and the speedometer registered at 140.
Okay, great. So you got it, okay? Y'all are doing great. And if you'll notice, he's the star of the show. She's asking very short questions. She's allowing him to answer the question. That's direct examination. He's the star. Now, a couple of things. I know why you brought this. Normally, a witness is not allowed to bring anything with them, okay? So they don't have any papers or whatnot. Of course, you don't tell the witness status, so I don't think. normally you wouldn't have anything in front of him. And so when he is this witness, one thing he's being evaluated on is how much we really, as the members of the jury, believe he is a police officer. So here's a question for you. How does a police officer sit?
Upright.
Yeah, right?
Nice
I mean,
posture.
good posture. What else about a police officer?
No swinging in their chairs.
Right?
Serious.
They might be very serious. What else do they do? Talk about their voice.
They assert.
Yeah, they're very assertive. That's part of the job. You have to intimidate with your tongue sometimes. So, as a police officer, you want to be projecting. You want to be loud. You want to be authoritative. You want to be not wiggling. You want to make sure that you are acting like a police officer. That is what a witness is scored on. Not only how they present the information and that they are accurately doing it, but how much you really believe that that person is who they say that they're trying to be, right? Okay, so whenever you are done with your questions, what do you typically do? What would you do then?
Questions may I answer?
Yeah, you would just say, no further questions for this witness, right? But I want to, before, well, actually, yeah, let's go ahead and have you have a seat. And so then you would pass the witness to the other side, right?
Yes.
Okay, and so who's going to be doing cross-examination here?
Sure.
Okay,
I
so
haven't read.
you what?
I'm still reading.
That's fine, that's fine. So you're going to do cross, right? So you're going to ask this witness what kind of questions?
Alternate questions. Leading.
Leading questions. Leading questions. So what are leading questions?
Yes. You get a yes or no
Yes or no.
answer.
Okay, so based on what you know about him, so he's the arresting officer, he's the guy who got the passport handed to him, blah, blah, blah. What kind of leading questions would you try to ask this kind of person? Now, for example, why did he get the passport? What led to that? What did he do that led to
The arrest of one.
Okay, but more specifically, what did he do that made the defendant give him the passport? He what? He pulled him over, and then what did he do?
You told him that he was speeding.
Okay, so he was speeding, and I mentioned it before, so that's why I'm kind of recapping. What did the officer make a comment on about the car?
That
Yeah,
it
all of the
was
license plates.
measuring.
License plate. And then,
Do not detain.
yeah,
Do not
so what would be a leading kind of question that you might want to ask him about what led to him getting the passport?
What was the actual purpose?
Well, even more fundamental than that.
Did you think he
Passport.
wasn't in the car?
Do you believe that he wasn't?
No, okay. So here's kind of where I'm going with that. So maybe I'm being a little intentionally vague, so my fault. Isn't it true, officer, that you asked the defendant about his license plate?
Yes.
And only after asking him about the license plate, only after asking him about the license plate did he give you his passport?
Yes.
Okay, so did he intend to defraud? I mean, I'm kind of thinking to that. Did he? No, he asked for it, right? He basically invited that response. So you might want to, so those are the kind of cross-examination questions. Make him look like he's the one that created this event. That he's the person at fault here, not your defendant who is completely innocent and just handed over that document in response to his question, right? So that's what you want to do on the cross-examination piece. You want to ask any other kind of cross-examination questions? Okay. So whenever you're finished, hey, you're not done yet. Whenever you're finished with this witness, what do? Yeah, pass the witness, no further questions, right? Do you have any other questions for this witness? Okay, so then, Your Honor, what can this witness do?
You may go down.
Yeah, you may step down. So you may step down. So that's basically how you would go through a witness testimony, right? So let's talk a little bit about our next witness, would be the Secretary of State, right? So let's go ahead and call our other witness. So which attorney needs to do that? Okay. So what are you going to do?
Ask, like, or maybe just call the Secretary of State.
So who's calling the Secretary of State? The prosecution, right? So what are you going to say?
Prosecution makes the please.
Okay, so the prosecution calls, and what's the witness name?
Kimball Park.
Okay, prosecution calls Kim Humboldt, right? So you're going to go up to the stand. Are you doing the, okay, doing the pro, he's trying to go for the pro, right? Beginner to pro in one session, right? Okay, good job. So, on this witness, I'm going to get you to walk through a couple of different things. I'm going to get you to introduce an exhibit. So why don't you grab out of your packet one of the pieces of information about the,
All the things that I have.
yeah, so maybe this one, because I bet she kind of talk about the queen or something like that. Yeah, okay. So, let's assume, everybody, that we've gone through the perfunctory questions, who this person is, and so forth, and she's talked about how she's the Undersecretary of State, or whatever it is that is her position. And now what we're going to go through is we're going to go through the introduction of an exhibit. Now this is straight out of the rules, okay? So I'm literally word for word right out of the rules. It tells you exactly how to introduce an exhibit. So here's how you do that. So we're going to walk through it together. So this piece of evidence that we're going to get, we're going to try to give it to the witness in just a second, and then we're ultimately going to get it in front of the jury. So that's our goal. So all the evidence is we pre-marked as exhibit. I don't think this one is. Doesn't have a little marking on it, but all the ones in actual competition do. So here's what you're going to do. You're going to ask for permission to approach the witness. So,
Your Honor, may I approach the witness with what has been marked for identification purpose as exhibit number 1?
and then,
You may.
okay. So you are going to walk up to the witness. Now you don't want to obstruct whose view? Who's the most important people in the room?
The
The jury. Okay, so you want to be cognizant of where the jury are, right? Okay, and so you want to then provide that exhibit. Now here's one thing that we didn't do, and I just want to kind of run through it. A first step in whenever you're doing your introduction of evidence is you're going to ask for permission, but the first place you're going to go is right over here. Why is that?
Just show,
To intimidate.
intimidate.
Yeah, you're going to show them the exhibit to demonstrate that there are no other markings or notes or anything like that, that it hasn't been altered in any way. So you're just basically presenting it to the opposing side and just say, providing it to counsel for review. Okay, so now you've approached your witness. So like I said, you show opposing counsel on your way, and you're going to then ask your witness to identify the exhibit. So,
I now have here what has been marked for identification as exhibit number 1. Would you identify it, please?
and so what is that?
It's Queen
Kingdom.
Kingdom Kalani, Kingdom of Hawaii, Restoration.
Okay, so you've identified what the document is that you're talking about. And so now you're going to ask the witness a series of questions to kind of lay the foundation of why this needs to come into evidence. So he's basically making the argument through these questions that this is an important piece of information that the jury needs to be able to see. Okay? So what are some reasons that the jury might need to be able to see this? Let's just talk about it real quick.
All right.
What are some reasons they might need to see this?
Because it's important since like the queen kind of just give away the Hawaiian Island kingdom or whatever to the United States.
Okay, and you're trying to establish and putting in this piece of evidence as the prosecution, what are you trying to establish?
We try to say that the queen has already did something which she just stepped down her throne, and I guess she had abdicated her throne and United States come to me then.
Okay, so basically you're trying to admit this piece of evidence for the purpose of showing that there is no more queen of the Kingdom of Hawaii, that this doesn't exist, right? Okay? So maybe think of a question or two that you could ask this witness talking about this exhibit.
All right.
Is Queen Yoko, is the Queen dead?
Yes.
Okay.
Wait, I don't know.
Yes.
So it'd be, the question might be something like,
Is the Queen dead?
Yes.
Objection, Your Honor, leading the witness.
yeah, right? It is a leading question. Good job. Okay, so the piece of a question related to this piece of evidence might be something like,
What is it about?
This is what I would say is maybe a piece of propaganda or something about this. Maybe that's what I want to make the argument. This is a piece of propaganda for this separatist group that is trying to create this country of Hawaii, this kingdom of Hawaii. And so, have you seen this before? Is this a piece of the propaganda that you were talking about earlier? Those kind of questions, right? And so we're trying to establish that she's already talked a little bit about and raised some information. This is relevant to what she was talking about, the testimony she was given about there being a separatist group, the people of Hawaii, etc. And so now that we've talked about what it is, we've identified its usefulness, now we're going to offer it into evidence. So what are we going to say?
Your Honor, we offer exhibit number 1 into evidence.
Okay, and Your Honor, you are going to ask?
Is there an objection?
Okay, and so what is opposing counsel going to do? First thing, you're talking to the judge.
No, Your Honor.
Talking to the judge.
Stand up.
Stand up. Okay, so it's only one of you, it's only the attorney who this is their witness. Okay, so whoever's going to be doing cross-examination, didn't you do the last cross-examination? So this will be yours. Okay, so you're going to stand up and say, is there an objection?
No, Your Honor.
Okay, and so now that there is no objection, okay, no, Your Honor, yes, Your Honor. If yes, then we would have to actually have a discussion over what the objection was and get a ruling on the objection. The court would ask for a response, we kind of go back and forth. But if there is no objection, then we would, what, Your Honor?
Exhibit number 1 is edited.
Okay, great. And so now what are we going to try to do? I don't have, it's not in the rules now, this is sort of the follow-on. I want to get it in front of who?
Judge.
Okay, so what am I going to ask the court to do now?
May I go to jurors, what is it?
Yeah, the word, and this is why I wanted to cover this, the word you would say is, Your Honor, may I publish this to the jury? So publish. It's not in the rules, and so that's why I want to talk about that. That last little piece is not part of Rule 4.20, but it is where you want to get to. So then you would ask.
Your Honor, may I publish the exhibit number 1 to the judge?
Okay. And so what he's going to do is he can just like set it, set it on the rail or hand it to one of the jury members or whatnot. But you're basically just trying to get it in front of the jury so they're focused on it, right? Okay. And so then once you published it, you can head back to your seat. No, you're going to leave it there.
Oh, right.
Yeah, you're going to leave it there. That's one thing to remember at the end of the trial. Make sure you get your exhibits back from the jury, or you'll be missing them the rest of the trial. So you're going to leave it there, and then you're just continuing on with your questions as if you were doing your direct examination. All right? Okay, so that is how we get a piece of evidence into the process. You look at the rules straight out of the rule book, and you can follow it like a script, and that's exactly what you need to do. The only things you need to remember, make sure you show it to the other side, okay? Make sure you've asked sufficient questions to get to the exhibit so that it makes sense to bring it in, and then make sure we get it over to the jury at the end when we publish it to the jury. Okay, so those are the things that are not in that script in the rules.
I have a question.
Yes, ma'am.
When you're showing it to the other side, what do you say?
Before you show it to the other side, you can. Some people will say, and that's a good question. May the record reflect I'm showing exhibit number 1 to opposing counsel. Okay, the reason you do that is in like a real trial, there's a court reporter sitting here, and so you want to get it on the record that you showed it to the other side. so that they can't come back on appeal and object that they never had a chance to review that particular exhibit. Okay, so that would be something you could say so it makes sense as to what you're doing. Okay, objections. Objections happen whenever the other team is doing something wrong. We had a good example of that. Objection, leading question, right? Whenever he asked a leading question on direct, definitely paying attention. So you need to stand and address the court. You're not addressing the other attorneys or the witnesses. You're standing and you're addressing the judge. So an example when you're questioning the witnesses would be non-responsive. Okay, what does non-responsive mean? Did y'all talk about this in the beginning session?
That the witness is not the respondent.
Yeah, the witness is not answering the question. Okay, they're not answering the question that I asked. A lot of times this would happen on cross-examination. So, let's say we're doing, are you finished with your witness?
Yes.
Okay, so what are you going to do? When you're finished with all of your questions, what do you do?
Your Honor, I have no further questions.
Okay, and so your Honor would call for what of the opposing side?
Do you have
Yeah, would you like to cross-examine?
okay, would you like to cross-examine the witness?
Okay, so now we're on cross-examination. Now I want you to ask a leading question of this witness. Remember, this is the foreign minister of the nation of Hawaii. So you're going to ask a leading question. I'm sorry? Oh, never mind, state of Texoma. That's right, I forgot, we're not on the foreign minister here. So this is the state of Texoma. She's just said things like, there is no kingdom of Hawaii, Texoma doesn't recognize it, so forth, right?
Yeah.
So what kind of questions might you ask this witness?
Does the state of Texoma recognize the kingdom of Hawaii?
And she's going to say what?
No.
Okay? Does she say anything in her witness statement about the United States?
Yes, she does.
What does she say about the United States?
That the United States did not invade or forcibly occupy Hawaii.
Okay. So, why don't you ask her this question? Why don't you ask her, isn't it true that you are the Secretary of State for the state of Texoma, and therefore you can't speak on behalf of the United States?
Isn't it true that you are the Secretary of the State of Texoma and therefore cannot speak on behalf of the United States?
Lie.
No.
Okay, so she just lied, right? She just lied. So, that would be an example of a time when we would want to impeach a witness, because obviously what she said is false, right? So the reason, well, we'll get into that, but I wanted to give an example. That is not the time for a non-responsive, because she did give an answer. Okay, the answer was wrong. So non-responsive, I just did that to kind of illustrate what a non-responsive answer is versus what a non-responsive answer is. Objection non-responsive means that the answer given did not directly address the question. This one did. Okay. In another example, what she might have answered instead of no might have been, I don't know, come up with some long rambling statement that you could say. You know, how about you say something like, what is your title?
Assistant Secretary of State for the state of Texoma.
Okay, so if she had answered that to your question, what might you say?
So do you speak on behalf of the United States?
Okay, so did she answer your question? Okay, so she is, no, she is non-responsive, right? So there's a difference. If what she says is untrue, you would impeach, and that's different. But if what she says is true, but it doesn't answer my question, non-responsive, okay? So, calls for a narrative answer, and you can have a seat. I'm just going to run through these real quick, and then we'll get into an impeachment in a second. So, calls for a narrative answer. They asked a question like, you know, what happened on June 22nd, 2016? And she launches into a 5-minute story. That's a narrative, okay? Ask a more direct, specific question about what occurred. If they ask a question multiple times, you can object to it being repetitive, asked and answered. If they didn't, what'd you say? What'd you say? Badgering a witness? Badgering a witness is not really an objection, but what it is when someone is being sort of hostile and repeatedly doing something. Lack of proper predicate or foundation, that might be, for example, he was trying to get in his piece of evidence. Maybe he didn't ask enough questions to get to that point so that it would make sense for that evidence to come in. Hearsay, I heard it from someone else, I didn't actually experience it myself, I didn't say it myself, etc. The outcome of any of those, the judge could say they're sustained. What does sustained mean?
Stay the same.
Like they,
It's correct.
they should
They
accept.
accepted.
Leave it alone.
Okay, so if he objected to her answer as non-responsive, and the judge says sustained, that means that what?
She
She
had all-
approved it.
Yeah, she agrees that it was non-responsive, that witness needs to answer the question, okay? If she said overruled, then what?
She did.
Then you need to move on to another question, okay? That's gone, move on. And if they say, I'll take it under consideration, take it under advisement, a lot of times our attorneys who act as presiding officers, if a team does something and it, yeah, that's wrong, you know, whatever, but they're gonna go ahead and allow it for the purpose of allowing the trial to go on, so that we get through everything. They'll take it under consideration, under advisement. What that means is I'll reflect that in the points, okay? But I'm gonna let them go ahead, just so that we can keep going with the trial, right? So that's kind of what that means, a lot of times we might hear that. Okay, unfair extrapolation. This is when a witness makes something up, okay? They just made something up, so like you lied a little while ago, okay? She made something up. You can object to unfair extrapolation, but the better practice is whenever, I'm going to just skip, is to go ahead and impeach that person. Okay, so let's go through impeachment real quick. So, you're going to follow the script, and I'm going to try to wrap up here in the next about 5 minutes or so. So we're going to try to run through the rest of this. So, go ahead and repeat back, what did she just state?
She said, you just stated that,
She can speak on behalf of the United States or something.
you just say that you could speak on behalf of the United States,
Okay.
correct?
Yes,
You gave a sworn statement about this case before trial, correct?
yes,
In that statement, you promised to tell the truth.
yes,
Your Honor, may I approach the witness?
And so what you're going to do is you're going to take her witness statement with you. Okay? And the first thing you're going to do on your way up to the witness is go where?
To, up, was it, sorry,